WordPress Accessibility Day 2024. Accessibility is a civil right, the digital accessibility legal landscape for the WordPress community, with keynote speaker Lainey Feingold, disability rights lawyer, author, and public speaker. This presentation was recorded October 2024.
Hello, everyone. Welcome again to WordPress Accessibility Day 2024. My name is Amber Hinds. I'm the CEO of Equalize Digital and the board president of the WP Accessibility Day nonprofit. And I am excited today to be emceeing our keynote presentation, which is Accessibility is a Civil Right, the Digital Accessibility Legal Landscape for the WordPress Community with Lainey Feingold. Welcome, Lainey.
Glad to be here. Thanks, Amber.
For everyone who has not had the opportunity to meet Lainey yet, Lainey is a disability rights lawyer, author, and international speaker who has worked with the digital accessibility space since 1995. She helped negotiate the first web accessibility agreement in the United States in 2000 and has worked with the blind community and dozens of communities and public sector organizations on accessibility initiatives since then. Lainey is the author of the book Structured Negotiation, a winning alternative to lawsuits, which was released in its second edition in 2021. She has been named a, quote, legal rebel, which we love, and a problem solver of the year by the American Bar Association, and twice received a California Lawyer Magazine Attorney of the Year award. Lainey serves on the board of Teach Access, a nonprofit collaborating with education institutions, disability organizations, industries, and governments to close the digital accessibility skills gap. We are honored to have Lainey here for our keynote presentation, and I know that you are all very much going to enjoy this talk. Please feel free to add any questions into the Zoom Q&A panel. I will come back at the end of the hour to pass those questions on to Lainey. And of course, you can continue chatting in the chat if you would like, but it is important to please get the questions in the Q&A. So thank you so much, Lainey. I will let you take it away.
Excellent. Thank you. Welcome, everyone. I'm so glad to be here. I do have a deck, which I am now going to share on the screen. Let's see. Okay. I think it looks good. Amber, you'll let me know if it does not. Yeah, so really glad to be here. I changed my shirt this morning when I saw the organizer were wearing orange, the color of the swag t-shirt, because it's a real honor to be part of the WordPress Accessibility Day and to be with all of you all around the world. I was so moved to see everybody's role and all the countries everybody's from and the sectors that everybody works for. So we're going to talk about the law. And as we said, the title is Accessibility is a Civil Right, the Digital Accessibility Legal Landscape for the WordPress Accessibility Community, the WordPress community broadly. I have my website up here, which is lflegal.com. I write a lot about digital accessibility best practices, the legal space. I write a lot about collaborative problem solving, which is how I've practiced law for the last 30 years. So everything on my site is Creative Commons. So I hope you will explore it and use what I write. Let me know about mistakes and corrections. It's really there for all of us to advance digital accessibility. I also have on this slide no legal advice in this talk. So please remember that. If you need a lawyer, if you have a legal question, please contact a lawyer. Everything I do in public, I try to share, what I know and to the best of my ability, but it's not legal advice. So a lot to cover. If you see me looking down, I'm looking at my timer I set because I want to be sure to stick to time. I'm not multitasking. Now I'm just, let's see. Okay, today's roadmap. There's a lot to talk about. What is digital accessibility? Why are we even talking about the law at an accessibility gathering? What are the frameworks, US and global? What are the remedies? Because laws come with remedies. And how are the laws implemented? What are my favorites in the legal space? I wrote here not so much favorites, but things I really don't like about the legal space right now. What we can expect on the horizon, little touch on law and WordPress contracts that you might want to think about. How can we talk about the law in a positive, advancing accessibility way without fear that so often accompanies legal conversations? And how can we stay current? My roadmap picture here is a road in Northern California. I'm here in my home office where I have worked remotely since 1996 in Berkeley, California. And this is a Northern California road, thus the roadmap. So let's get started. What is digital accessibility? In the background of this slide, just to know, it was also in the background of the front cover, are two leaping dolphins. And I have adopted the dolphin as a counterpoint to the sea creature that is so often associated with lawyers, which is shark. And there was a book written called Teaching Baby Sharks to Swim. And it wasn't about teaching sharks, it was about teaching lawyers. And I knew after 30 years of collaboration in the legal space, well, it was about 25 years when I heard about this book, I needed another sea creature. So I use the dolphin as a metaphor for collaboration, for relationship building, for sustainable accessibility without fear. So the dolphins will be in the background swimming around in some of the slides. I like to think of digital accessibility as the engine of disability inclusion in tech. It's the difference between inclusion and exclusion for disabled people, the difference between inclusion and exclusion, and the intentional practices that make inclusion happen. And that's really what this day is devoted to, learning and sharing information about the intentional practices that make inclusion of disabled people a reality on the web in today's tech. Digital accessibility is privacy, it's security, it's safety, and it's so much more for disabled people. And it's also ethics. Digital accessibility is ethics because it's about autonomy and privacy and choice and fairness and non-discrimination. So I like this picture of a door, very closed up, paint's peeling, looks like it hasn't been open forever. There's double locks on it. That's really what it is when technology is not accessible. Disabled people are locked out. Instead of like this, the open door with the light shining through, because in all the work you're doing, whatever your role is, and it was, like I said, so gratifying to see so many roles there, whatever your role and however much you know and whatever you're doing, you're a door opener. You're a door opener because accessibility work opens doors for people. Also, digital accessibility is a bridge to everything. This is a picture of a bridge in India. I spoke at Barrier Break's Inclusive India conference last year, which was such a joy. It was really great to see people from India on the list of participants and here on the conference today. So much accessibility work gets done in India. I'm connected with blind lawyers in India who are doing incredible work advancing accessibility there. I feel like India doesn't get enough attention in terms of its role in advancing accessibility. So this is why I chose the bridge. And I like to say digital accessibility is a bridge because on one side are all disabled people. You know, people who can't see a screen or have cognitive or learning disabilities or can't hear a video or can't hold a mouse. And on the other side, everything tech, which means that you're not just a door opener. In my mind, you're a bridge builder too. So the reason I start with what is digital accessibility is because if we only think of accessibility as a checklist or a burden or some narrow thing we have to deal with, and we don't think of digital accessibility as something that opens doors for disabled people and connects disabled people to tech, we can't really understand why it is that we're talking about the law at an accessibility conference. The reason for talking about the law at an accessibility conference is because accessibility is a legal right. You know, I use the word civil right in the title of this talk, and as I was preparing it, I was thinking, well, what actually is the difference between a human right and a civil right? Because in the US, we tend to talk about civil rights, and I've seen it around the world and with global treaties, they tend to talk about human rights. So something I probably should have known a long time ago, and many of you probably do know, human rights are the rights we acquire by being alive, things that should be our inherent right as people, and civil rights are those that we get from laws where we live. So people's civil rights might be different in different places, but human rights are everywhere. And digital accessibility is both a human right and a civil right, because it's about participation. Think of anything you do, anything you're working on, whatever sector you're in. If you're on accessibility, you're on to helping people participate. It's about inclusion, not exclusion, which is why I have the exclusion double struck out on the slide. It's about communication. It's about education. It's about health and safety. Just think what's going on in Florida in the United States right now, bracing for another terrible climate crisis hurricane. So much information spread out on the internet, digital. Without accessibility, it's a risk to disabled people. And that's just one example, and so much more. So I illustrated this slide with a picture of a protest march in the run up to the Americans with Disabilities Act. There's a lot of people in the front you can see a couple of people using wheelchairs and someone with a guide dog, and there's a poster that says access is a civil right. We shall overcome. And the reason I put this in is a reminder that these laws that we're talking about today, they don't just fall from the sky. They are the result of organizing and work and commitment and blood, sweat, and tears of people with disabilities and allies. So that's certainly true about the Americans with Disabilities Act, and I know it's true around the world too. So another opportunity when we talk about the law to talk about people is remembering where these laws came from. So these rights, human rights, civil rights, are baked into laws. I like baking analogy. I have raw chocolate chip cookie dough with yummy, it's a close-up, you see the chocolate chips, to illustrate the fact that these aren't just ideas, human rights and civil rights, are baked into actual laws. And I really like this quote from a woman named Lizzie Kiyama from Kenya, who I heard at the Microsoft Ability Summit in 2021. The legal framework gives us permission to dream what is possible. The legal framework gives us permission to dream what is possible. And here in the US, we have a very strong and complex framework that we often see, like I said, as a burden or something. Oh, the lawyers who get, so many people say the lawyers, they get involved and it limits, or they say no. Lawyers are not just associated with sharks, or associated with the no. Although I know many lawyers, hopefully in your organizations, are in support of accessibility and say yes. But really important to remember that having laws allows us to have a society, or to dream of a society where everybody's included, including the 1 in 6 people around the world who have disabilities. So what does that framework that gives us permission to dream look like in the US? Okay, here's the components of the US legal framework. We have federal laws, national laws that apply across the whole country. We have regulations based on those laws. We have policy statements from the government. We have state laws in all 50. There are state laws in all 50 states. Many states have accessibility or disability inclusion laws. We even have local laws in some cities and some counties. And then we have implementation of all that. And that all works together, which is why I have a picture here of gears kind of showing that they're working together. One says state and local, one says implement, one says federal. So those are the components. Obviously, all we can do today is a very high bird's eye view, but I think it's important to remember how robust that framework is, because you hear a lot of, oh, somebody lost an accessibility case, and it seems like a bad thing. Probably is a bad thing. However, we have a very strong foundation and a very strong framework. So let's just look quickly at the existing laws and regulations in the United States. Of course, we have the Americans with Disabilities Act. There's 2 components of that we can all put in our pocket while we're talking about the law. One of them is that the ADA is an anti-discrimination law. Its foundation is we can't discriminate against disabled people. Second, it's a law that requires effective communication. When we're talking about the web, inaccessibility, of course, discriminates, because people who have disabilities can't participate in all these other things we talked about. And effective communication, what is web and technology about? It's about communicating. And that is why, even though the ADA was passed over 30 years ago, since almost the very beginning, the law has recognized that the ADA applies to the digital space. And I don't really have time to do this, but I just love this quote from 1996, where someone asked Senator Tom Harkin in the United States about the ADA and digital. And yeah, someone asked Tom Harkin, and Tom Harkin asked the Department of Justice, and the Department of Justice, which is in charge, the administrative agency in charge of the ADA primarily, the Department of Justice said, covered entities under the ADA are required to provide effective communication. This is 1996, regardless of whether they generally communicate through print media, audio media, or computerized media, such as the internet. Covered entities that use the internet for communications about programs, goods, or services must be prepared to offer those communications through accessible means as well. So since 1996, this is why the ADA, even without regulations, has been such a strong proponent for accessibility. We have Section 504 and 508. You can also put that in the pocket. Section 504 is just about federal government's going to spend money. It can't give money to organizations that discriminate against disabled people. Section 508, federal government's going to buy things. It has to buy accessible. That's why 508 is basically a procurement law, as well as a law that protects the rights of disabled people to work in the federal government with accessible technology. The Communication Video Accessibility Act and the Federal Communications Commission, that's about captioning and audio description, and there's lots of rules about that. But again, the bottom line is, are disabled people going to be able to participate in communication technology, or are they going to be excluded on the other side of the bridge? The Air Carriers Access Act, special law for airlines, also requires accessible websites as well as kiosks. And the Affordable Care Act, the ACA, Section 1557 is about accessibility in healthcare technology covered by the Affordable Care Act. So that's the big framework of existing federal laws and regulations. For each law, there's a lot of regulations. We don't have time to get into it, but I just want to do not even a deep dive, a somewhat shallow dive into the brand new ADA web and mobile rule, which just was finalized in April of this year. I use the word regulations. Sometimes in the US, they're called rules. Rules and regulations, kind of the same thing. So the new ADA web and mobile rule is a rule that applies to state and local governments only. I know a lot of you work in state and local governments. It's not just the state or the city, it's any program of states and cities. Put up a few pictures here of a county jail or a state university or my hometown library, the Berkeley Public Library, a park system where I have a picture here of someone in a power wheelchair on an accessible path. So all state and local governments, people often ask me, well, is it going to apply to private sector next? It took 14 years to get these regulations, and the whole history of it you can read about on my website. So the fact they did state and local government doesn't mean, oh, tomorrow they're going to do private sector. However, it does mean that we got that out of the way. We can now focus on private sector. So the standard is Web Content Accessibility Guidelines 2.1 AA. The time frame depends on the size of the state or local government organization. If it's over 49,999 people, basically if it's 50,000 people or more, then the deadline is April 2026. And if it's less than that. If it's a smaller organization, it's April 2027, recognizing that it takes time to do these things. But it's important to remember in the time frame that the ADA is not suspended. Accessibility is still required. And the Department of Justice has a very good fact sheet on this. And if you look up fact sheet, Department of Justice, web accessibility, state and local government on, you could do that at my website or do it on Google, you get the fact sheet. And that has all the details. And they say in there, the ADA isn't suspended. And just recently, in the past year, the Department of Justice did a settlement with the whole state of Oklahoma because their mobile app that allowed you to put your ID onto the app wasn't accessible. So ADA is still chugging along while these regulations come into play. What's covered? It's web and mobile only, doesn't apply to anything else. Pretty much everything on web and mobile. And a really important thing that they call out is if you're a library and you say you're buying something for your website or you're hiring a third-party developer, the state and local government agency is still responsible. You can't get off the hook by saying, well, I didn't build it, I hired someone to build it. There are some exceptions. They're very narrowly drawn. Just one quick example, and these are all in the fact sheet. Just one quick example is social media is covered. There's no requirement to go back and make old social media posts accessible. There's no requirement also to go back and make individual documents. They particularly call out like word processing documents, PDFs, spreadsheets, those kind of static documents. No need to go back, but still the ADA still applies. So if you're an agency, you need to have a plan in place to make particular things that might be in the exceptions to make them accessible too. So that's this new rule. There's a lot about it on the web. I encourage you to take a look at it. Beyond regulation, the United States federal government can do things that explain the law. I have a picture here of sort of to represent telehealth. It's a Black medical professional. She's writing notes, and the guy on the screen looks like he has a flu or something, which is to illustrate the fact that the Department of Justice and Health and Human Services, they have really good guidance on telehealth and how that needs to be accessible and healthcare in general. The DOJ and the EEOC, which is the Employment Federal Agency, Equal Employment Opportunity Commission, they have a really great guidance on AI hiring tools and the risks to disabled people if disability rights and civil rights aren't considered when using AI hiring tools. President Biden has issued executive orders on AI that include disability, and the Department of Education, Department of Justice have what they call a Dear Colleague letter, which is guidance. I don't know why they call it that. I don't think anyone else in the federal government does, but it's all about the importance of accessibility and digital inclusion for disabled people in the higher ed space. So I have articles on all these things, except for that President Biden's AI order, which is on my to-do list. I have articles that link to all these things on my website. So I encourage you to check those out if you're in that sector or you're interested. I have to say one other quick thing here. These federal agencies, they are not buildings. The people who work in them are not robots. So as probably all over the world, but especially in the US, know that we have a very important election coming up in less than a month. And all of this work, you notice the dates up here, they're at 2022 and 2023. Not only would it be my guess that it won't continue if the Harris Waltz doesn't win, but these can all be rolled back because the head of all these agencies are appointed by the president. So it's really important. We talk about the law in the abstract, but it's actual people doing the actual work. And the heads of all these agencies have been appointed by President Biden. So keep that in mind when it comes time to voting. Okay, back to the framework. We have that framework. That's the federal framework. There's also laws in individual states, which is why I put an image here that shows the 50 states in different colors, because every state has different laws. So you need to pay attention, not just to the state that your organization works in, but to the whole country. Because if you have a website, it's not going to just be available in Kentucky or California. It's going to be available everywhere. So it's important to meet the highest standard. Again, this is not legal advice, but that is what I recommend. One sort of hot topic is, can you file a lawsuit about a web-only business? And you'll see if you're on social media, there was a recent case last week where a court in New York said, in this court, you can no longer file web-only. Has to be connected in some way to a physical space. Like you have a retail store and You go online to see what's available, then you go to the store. But that's not the case all over the country. Other parts of the country say, the courts say, you can have web only. And that's been since 2012, when there was advocacy around Netflix captioning, and a court there said, yeah, ADA requires captioning. Netflix doesn't have to have a physical place. So it's important to know about the state laws. There's many laws that have anti-discrimination, just like the ADA. There's same thing, state funded. State's going to fund something, can't discriminate against disabled people. State's going to buy technology, needs to be accessible. There's state agency requirements. There's a great new law, relatively new in Maryland, which I think is the only one there. Someone could maybe put in the chat if they know of a different one, about the requirement to purchase accessible technology for K-12 education. So that's in Maryland. You can find more information about all these state laws in the global law and policy page on my website, because part of the globe is the US. So I have a section on state laws with links to these various state laws. And you can find that on the top navigation bar. It says legal update. There's a drop down global law and policy. And I've also written some articles about it on the site too. So what about globally? I wish we had 3 times the time, but you have such an exciting program for the next 24 hours. I'm going to stick to my time. All I can say about global is this: accessibility is global. And I have a page on my website, which is lflegal.com, global-law-and-policy, which is the one I just mentioned, available from the drop-down menu. I want to give 2 shout outs about this page. Well, first, let me say I have countries listed by region with digital accessibility laws or policies related to those countries. Of course, I don't have all the countries, but I have to give 2 shout outs. First is to my web developer, Natalie McLeese, who you will be hearing from as a speaker later today and is one of the founders of WordPress Accessibility Day. And I am so lucky and blessed that she is my web developer for many years, also made my beautiful slide template. So Natalie built me on the back end of my WordPress site a really easy way for me to put in a country, put in the region, put in what the laws are, press go, and it populates on this global accessibility page, which is good because I can make changes and I can do it all myself, even though I'm not a tech person. The other shout out for this page goes to more than 35 people who sent me the information you will find. So we mentioned India. The lawyers from Mission Accessibility sent me that information. In France, where I just spoke at Paris Web, Julie Moynat, who's a accessibility person in France, she sent me the French information. So I encourage you, if you don't see your country on there, please, if there's anything that should be included, I hope you will send it to me. If you see a mistake, if you see something missing, please let me know. But I was really glad to do this page. I was really glad to do this page. I'm glad to keep it going as long as we can. Okay, so what about the remedies if the law is ignored? Have a cup of tea. That's a remedy for a cold. Well, laws include remedies too. And different laws have different remedies, but that framework includes the remedies. Many laws require you to fix barriers and fix systems. You could end up with court oversight. In the United States, the Department of Justice can issue penalties up to $150,000. Honestly, they don't do it very often, but they can. You might have to get involved in the wrong side of a lawsuit. You might have to pay the disabled person. You might have to pay their lawyers or your own lawyers. In the European Accessibility Act, there are potential fines, there's market loss, there's potential jail time. So what I switched the picture from the teacup to a keyboard with keys that say reactive, proactive. So we may as well be proactive and fix the barriers, because you're going to have to fix the barriers if you get involved on the wrong side of a lawsuit, and you could tell your developers, tell your clients that, and you get all this other stuff. But if you fix the barriers, you don't get the court oversight and the penalties and lawyer fees. So fixing the barriers, should say building the systems accessible to begin with, super important. Okay, but without implementation of all this framework, the cookie dough is still unbaked. So how does implementation happen? Well, implementation, how are laws implemented? Who and how? I have an image here of a student speaking in sign language because first of all, in the United States, and this is true all around the world, I think, people with disabilities are enforcing these laws all the time, not with lawsuits, not even with kinder, gentler, structured negotiation collaboration, but by filing feedback and communicating with site owners. And they're not saying there's a wcad violation, and they're not saying that there's a legal violation. They're saying, I can't find something. I don't see something. I can't locate. I don't know how to get there. So if you have any way of feedback, a feedback loop that really works in your organizations and recommending to your clients, so important, because that is the first way the law is enforced and can maybe get you away from having to get into other enforcement. Also, the government agencies, there's private party lawsuits in the United States. Don't have a lot of time to go into the fact that I think some of those lawsuits right now are not ethical lawsuits, which we'll talk about in a minute, but there still are ethical lawsuits that disability civil rights lawyers use to enforce the framework we talked about. And then structured negotiation. If you're interested in structured negotiation, like I think Amber said in the intro, I have written a book about it. It's not just for lawyers. It's available all over the world in English, supposed to be available in Spanish soon. And on my website, in the settlements tab, you can see most of the cases that I worked on in the past many years. In the European Union, I'm very excited about how enforcement's going to go when the government, when the laws come online. I mean, they're online, but when the implementation date starts in 2025, because you have a surveillance authority, it kind of mainstreams accessibility, like can't put unsafe things in a market, can't put inaccessible things in a market. There's enforcement through self-declaration and through advocate complaints. And globally, this is different in every country. And I encourage you to know how the laws are enforced in your country. And again, if you see it missing on my page, please send it to me. What are some of my favorite US actions? Got the fireworks going. Okay, education, there's a lot of good things going on. I have a picture here of a woman who's, listening to a speaker with her iPhone and her computer in large print. And there was a verdict against Los Angeles Community College District of $240,000 for not providing accessible information. This is on my website too. There's a lot of settlements with universities that you can look at as a roadmap for what the Department of Justice and private parties require. There's cases about continuing ed accessibility, state licensing exams. Department of Education does civil rights complaints. There's a great resource if you put in higher ed accessibility lawsuit tracker or higher ed accessibility lawsuits, you will find a resource from Laura Carlson at University of Minnesota that I rely on to find out what's happening in the education space. So there's a lot of good happening in the education space, a lot of good happening in voting. Both Department of Justice and private parties are using the ADA in the way it exists now to make sure disabled people can vote, which, needless to say, very important. Couple cases where that whole framework I talked to you about, that's within a bigger ecosystem of US law. And there's a couple of examples I just want to share really quickly where people are using non-disability law to advance digital accessibility. One of my favorites is this one, which I titled the slide, Don't Lie About Accessibility. Picture is a woman holding $100 bills on fire because this was a case against California Parks system because a website was supposed to be accessible. It was in the contract. The developer handed it over to the state and said, this is accessible, but it was not. And that website, the cost, it was for a park system and reservation. So the price of it fluctuated, but it potentially could have been like over $5 million. They paid for this website that wasn't accessible. And there's a law in the United States usually used in military contexts, like military contractors sell something and lie about the cost, called the False Claims Act. And that's what blind advocates did to say, hey, you lied to the park Parks Department, this site is not accessible. So the contractor and the web developer and the subcontractor were sued. It was recently resolved for $2 million and fixing the barriers. So back to the proactive reactive, if they had fixed the barriers, if they had a procurement process that didn't allow broken things into the system. Procurement is so critical to digital accessibility generally and in the legal space. If they had had that in place, they wouldn't have had to do all these other things. Another one, be fair and honest. This is a case called Tribeca Skincare versus Accessibate, which is an overlay company. And many of you are familiar with the overlay fact sheet and problems with overlays. So I'll just leave it at that. I've been very vocal about that in my writing and speaking. But for here, you just need to know that a lawsuit was filed by a small business who bought the overlay, used it for 2 years, paid the licensing fee, and then got a lawsuit because their site wasn't accessible. And so they hired a lawyer to file a business case. These are disability rights lawyers. I've since met them and they seem great. I love this case. But they filed a breach of contract, a breach of good faith and fair dealing. I've written about this case on my website, which is basically to say, like, don't lie. Like we just said, don't lie about accessibility. Be honest in your transactions. Be clear about what you're providing and provide what you say you're going to provide. So this is a case that we all really need to watch because it's the biggest sort of, I think, biggest potential case to put a halt or slow down the overlay problem. Beyond websites, the law is doing a lot of things, kiosks, VR captioning. I have pictures of healthcare kiosks. There's settlements about that. There's VR captioning case that was settled. There's a case pending about podcast transcripts. And this is all under the ADA, under the non-discrimination and the effective communication. Those things we can just put in our pocket to talk about the ADA in a way that centers people. So I have a resource on my website called Kiosks, the law is paying attention. I've kept it for many years, and every time there's a kiosk case, and there's also kiosk resources, I put it in that article. So I invite you to look at that. Least favorite parts of the US legal landscape, you can probably guess. One is the numbers. The lawsuits for 2023, there were 4,605 digital accessibility cases filed, primarily web and mobile, mostly web. 25 of the cases against defendants already sued, 933 against companies using an overlay. UsableNet is a consultancy that does the numbers. They do monthly reports. I don't have any way to double check it, but as far as I can tell, these numbers are accurate. I don't like all these cases because it takes accessibility and the law out of the realm of people, out of disabled people, and it encourages fear. So, and I think it also encourages the overlays because people get scared, understandably so. They're going to get sued. They look for a quick fix. They go to the overlays. So that's the other part. Overlays and slap. I have a picture of Darth Vader because this is the dark side of digital accessibility right now. There have been cases against accessibility advocates, both in the United States and France. Fortunately, the one in the United States against Adrian Rosselli has settled. One of the French ones has, one hasn't. If you don't know the overlay fact sheet, please take a look at it. What might happen in the next 2 years? What might happen in the next 2 years? First of all, the answer is nothing, because if Donald Trump gets elected and the Project 2025 blueprint for conservative presidency gets implemented, we're not going to see anything. We're going to see rollback. We're not going to see new laws. So again, Project 2025, if you're not familiar with it, I have an article on my website about the impact of Project 2025 on people with disabilities. As I said, it's a blueprint written by conservative, the right wing in the United States. I encourage you to look at it. But everything's looking good for Kamala Harris. So let's assume she does get elected. What might happen in the next 2 years? There's a couple of accessibility laws out there. One is the website and software app law. It's been pending since the fall of 2022. There's a Communications Video Technology Accessibility Act to upgrade the CVTA. One thing about the website law is it specifically obligates developers to meet the standards. The way the ADA works, you only can go after the state and local government or the private website owner, but they're trying to expand that, which is only fair to the developers who are delivering the websites and the technology. So those are pending. I mean, a lot of time is spent and a lot of words written about laws that are pending and what might happen. And I encourage you to stay up to date. That's one of the reasons I do these talks and write these articles. But we can't lose sight of how strong the framework is already, which is why I read you the quote from 1996. There was a California bill that got so much attention, it never passed. It didn't happen. It was called California Bill 1757. And the European, we're talking about what's happening in the next 2 years, this really isn't under proposed because there are European Accessibility Act country laws, but we're going to see the implementation. So I'm really excited to see how that is going to play out across the European Union. And I'm going to be following that and trying to write more about that. Pending and possible accessibility regulations. We're supposed to have kiosk regulations. We don't have them, but like I said, the ADA is chugging along, requiring kiosks. The EV, electric vehicle charging station regs, were just put out in draft form. The Department of Education is supposed to update their regs. Don't wait. The law is strong. Okay, I only have 3 minutes, so we talked about these things. I want to have a little time, I guess 1 minute each for, let's talk about the law in the WordPress developer client contracts. Okay, this is a place that's really important to remember, no legal advice, but I can recommend that you be very clear in your contracts. I'm not telling you what to say, but I always think it's a good idea to be clear in your contracts about what accessibility standard is going to be used, what testing is going to be accomplished, who's going to do it, when's it going to happen, what are you saying about legal compliance, what are you promising or not promising, what about third-party work that you don't really control but is part of what you're delivering, who's going to fix barriers after the fact. The accessibility and web development contracts is a really good article that alerted me to this, that Amber alerted to me to it as well in her podcast. And Amber, when you come back on with the questions, please tell people where they can find this. It's called Accessibility and Web Development Contracts, and it's in quotes. So if you put that in Google, you'll find it, but Amber will tell you more. Reminder, this is not legal advice. How to talk about the law and digital accessibility. Don't be a shark. I already told you I don't like sharks. I have a big X on the shark. We need to use the law to encourage people that digital accessibility is not just the right thing to do, but it's a required thing. But if we approach it with anger and fear and bloodthirsty and, you're going to get in trouble, not motivating. So I say don't be a shark, be a dolphin instead. I like this picture, the dolphin and the tube. They're getting the fish out of the tube, and if they didn't work together, they would not get the fish out of the tube. So, I offer talks, actually 5-hour trainings about what does it really mean to be collaborative. And in my 30 seconds, I'll just say, you got to really listen. You got to know who you're talking to. You got to speak the language. And when talking about the law, try to talk with ideas about people instead of fear. Talk about civil and human rights, focusing on people, inclusion, exclusion, privacy and security, diversity, inclusion, and belonging, products for all, ethics, risk mitigation, efficiencies. These are all embodied in the law. I have an article on my website called Accessibility is Delicious. And my clock gave me my 40 minutes, which is another sort of group article, collections from all over the world that started with, you can't put the blueberries in the muffin once the muffin is baked. And one of them is this, a melted ice cream cone. Accessibility is like an ice cream cone. If you do it late, it's very messy. And I'm sure you've all heard people say, oh, we'll just do that later. But no, not only is it messy and not efficient, but it's also required by the law. So I think I'll just stop with the resources. Really recommend the DOJ email list. Access Board has an email list. They do some of these regulations. On my social media accounts, primarily LinkedIn now, I have an email list. Hardly ever use it, but you're welcome to sign up. And when I do, you'll find out, things about the law. Safe Art ADA Title III blog for ethical defense perspective. Yeah, I think I'll stop here. A couple more things, but we'll see how the questions go. I want to be respectful. Amber, back to you.
Great, thank you. I'm going to wait just a second until there we go. Hi, thank you so much for that wonderful presentation and for packing so much information in. For everyone, Lainey's slides are available on the website in the schedule session, so you can find those if you want access to any of those resources. I did also post a link in the chat to the blog post you were referencing about accessibility in contracts. We have a few questions and we have about 6 minutes. So I'm going to try and get us through those sort of quickly. So Tom had asked, do you know what would happen for state and local government under the ADA ruling if they're not compliant by April 26, 2026? Is there anything specific to that?
Well, the rule is part of the ADA. So the way the ADA is enforced, those remedies, those would apply through lawsuits, structured negotiation. The Department of Justice can do investigations. They can, they have a whole claims process. Disabled people can file claims with Department of Justice. Department of Justice can investigate. They can do settlement agreements, like I mentioned with that Oklahoma mobile app case. They have done a lot of work on accessibility for many, many years. So whatever the remedies are and the implementation issues for the whole ADA, that's going to kick into effect for the Title II regs.
Okay. Susan had asked, are there state and local laws that are more strict than federal laws?
That's a very good question, something that got lost in having to go too fast. The one big difference is that the remedies for the Americans with Disabilities Act include fixing the problem, which is very important, of course, as well as paying the lawyers for the disabled person. And this is true in the US, usually you have to pay your own lawyer. But in discrimination cases like race, gender, disability, the rule is that the fee requirement shifts. They call it fee shifting. And if a company discriminates, they have to pay the fees of the lawyer for the disabled person, which is how that's my business model. That's how I've always been paid. No person with a disability has ever had to pay me because of this.
Okay.
In some states, sorry, didn't mean to get distracted. In some states, there's also requirements that the disabled person can be paid money. And one case to watch on this is one of those kiosk case against the check-in kiosks at I don't remember if it's Quest or LabCorp, but that case has been given the stamp of approval to proceed as a class action in California. And that means there's a potential for a lot of money coming out of California. So the strictness more has to do with money, and you'll see in the cases, most of them are filed either in California, New York, Florida, where they do have money. Yeah.
Great, thank you. So someone said for the Title II state and local government requirements, I recently heard that any healthcare organizations like physician practices that receive Medicare or Medicaid reimbursements must also be accessible on their websites. Is that true? And my knowledge of this is that might also come from the Affordable Care Act.
I was just going to say that. Yeah, that research on my website about telehealth, if you just search telehealth on my site, search engine or through Google, it has a lot of that information about the Affordable Care Act, links to the regulations and the requirements. So that's where that would be, I think. It wouldn't be under Title II, because Title II only goes to state or local government. And of course, if it's a healthcare operation that's a state agency or something, then yeah. But if it's a private doctor and they're getting Medicare funding, that would either be 504 Health and Human Service Regulations or Affordable Care Act.
Okay.
Again, the question and answer is also no legal advice in the questions and answers. I'm giving you my best, but yeah.
No, and we appreciate it. I think we have time for one more quick question. I'll just note, someone did say that they were looking for a link to the FAQ document and they couldn't find it. So I'm going to hope maybe that you can stay on and just post a link to that in the chat when you're done. If you could do that, because they said they're searching your website and can't find it. Do you know if there's current guidance? Oh, sorry, go ahead.
I would look at, just real quick, I would look in Google for fact sheet. I wouldn't look on my website. It's linked, but it's complicated. There's WordPress glitch in getting the updates to show up in the search engine. So I would look on Google for fact sheet. I will still put it in here, but look on Google, fact sheet, ADA, DOJ, web access. Yeah, sorry, go ahead, Amber.
Great. I actually think that might be our time because we need to give our captioners and our interpreters a break before our next session. So thank you so much, Lainey. And feel free to hang around and answer a few questions in the chat if you want, or of course, anyone can follow up with Lainey. She's at LF Legal on socials, and you can find her at lflegal.com. So I'm going to do
I even put my email up here, lf@lflegal.com. So either through my website or the email. Thank you so much. Have a wonderful rest of the day of learning accessibility goodness.
Thank you, Lainey. Thank you, everyone, for attending this session with Lainey Feingold. You can continue the conversation in the chat or on social media using hashtag WPA11YDay and hashtag WPAD2024. Please go to 2024.wpaccessibility.day/feedback to provide anonymous feedback for our speaker on her presentation. You can also enter to win one of these fabulous t-shirts while you are there, if you would like to. Stay tuned for how to remediate accessibility issues in WordPress, coming up next with Cam Coulter at 1600 UTC. And while you are waiting, don't forget to visit our sponsors pages to grab virtual swag and enter for a chance to win great prizes. I'm signing off as MC. You'll have another MC coming up soon, and we'll see you back here after the break.
Thank you to WordPress Accessibility Day 2024 sponsors. Platinum sponsor 20i. Easily build, deploy, and manage all your projects with 20i managed WordPress hosting. One UI for all your servers, apps, sites, databases, security, DNS, and email. Perfect for agencies, e-commerce, developers, multi-site hosting, and high-traffic sites. Platinum sponsor Equalize Digital. Since all they do is accessibility, every post on their blog is an accessibility resource. You can find webinar recordings, articles, and additional resources at equalizedigital.com/resources. Platinum sponsor, WP Engine. WP Engine provides the most relied upon and trusted WordPress products for businesses, brands, and agencies of all sizes. Thanks to our gold sponsors, GoDaddy, Grackle Docs, Gravity Forms, Green Geeks, TPGI, and Yoast. And thank you to our silver sponsors, CodeGeek, Drake Cooper, Elementor, Overnight Website, Pressable, Second Melody, and Accessibility Collective.